that should not be held against the defense. But I point out that we litigated this issue. The state filed motion 4.54, a motion to exclude mention or reference to any argument concerning George Barnhill's letter to Captain Tom Jump of the GCPD, or his meeting with GCPD about this case, or Barnhill's opinion of this case. That got expanded to the notion of whether any discussion about Jackie Johnson, and this was before her arrest, could be addressed. And in open court, the court accepted the agreement between the parties on the record that we would not be addressing the time lapse that was between the date of February 23rd and the May arrest. In fact, we knew that one of the reasons was it was incendiary, and especially after Jackie Johnson's arrest. So it was so important and so critical that we included it in voir dire, and most of the people who responded raised their hands and said that they had an opinion about the lapse of time and were questioned about what they knew about that, and many of them had knowledge of some connection, they believed, to Greg McMichael. And again, I point out the court's bond order denying bond, in which one of the reasons set forth by this court was a connection that this court drew between that lapse of time, Jackie Johnson's decision concerning the way she handled her recusal, and that the McMichaels, specifically Greg McMichael, may have played some role in that. I can pull the bond order up a little later. There's no written order, so we are not moving for a mistrial for the court for the state having violated that agreement that the court accepted as a resolution to the state's motion. But what we are asking is that the court know that the state cannot introduce evidence that suggests that there is a time lapse or that nothing happened or that GCP didn't act, and then just leave it hanging out there for the jury to draw any inference from. There should simply be, based on our discussions with the state, the GCPD investigation, and then whatever it is they believe that's relevant about what the GBI did, with no comment and no evidence concerning that time lapse. That's number one.
Let me just get from the state then.
Thank you, Your Honor.
We join in the motion, Your Honor, and we might want to address it when she's done.
Well, no, let's address the defense side of it, and let the state, instead of ping-ponging this back and forth.
May I just go as part of the McMichael team?
May we confer?
No, I don't need to confer. You can make yours. I'm going to make an additional statement. That's all.
Okay.
Go ahead.
Well, if I could have a moment, I want to make sure I'm not mistaken. So.
Just so I understand the request, what I understand is you are trying to put a finer point on and clarify what the agreement was with the state. You're not asking the court at this point, excuse me, for any type of instruction, or I just want to make sure I'm clear, or we're just putting it on the record and making sure that we're all on the same page, as I understand it.
Well, I am very sure about what the direction was and what the agreement was. I'm making sure that the court is making sure that the state intends to comply with that. An opening statement is supposed to be a window into the evidence they're going to present, so it concerns me as if they would be presenting evidence in support of what they argued in their opening statement.
Okay, I understand.
You know, my inclination was to go ahead and make the motion for mistrial. I don't know why we're not doing that. I don't think we're going to be able to unring the bell that has been rung by the prosecution a moment ago I'm sure maybe there's an explanation for it, but it sure seemed to me like a violation of the prior understandings upon which we were trying this case. I couldn't even begin to suggest a curative instruction. I don't know how you fix the problem. But the bigger issue, I guess for me, Your Honor, but beyond that, just anticipating your court's not likely to grant a mistrial before any evidence is actually heard of the case. You know, we had a fairly lengthy discussion the other day. I filed a motion in limine. I sat here with a written motion to sever, ready to be filed, and, you know, we backed away from that. I brought to the court my concern about this after-the-fact conspiracy and how, regardless of the state's intentions, you're not going to be able to separate this thing with Jackie Johnson, the police department, the lapse of time from the other stuff. So, you know, even if the state doesn't grant a mistrial, the state has pushed the Bryan defense closer and closer before they've even started presenting evidence to a severance. Because how would we avoid from Mr. Bryan the spillover effect of all this other prejudicial, extraneous matter, which now the state has put out there in opening, and cleverly, I think, maybe not as clever, maybe not cleverly, maybe we'll leave that for later. But we have tied in through the voir dire process, by implication, the knowledge of the jurors about the unindicted fourth defendant and the lapse of time. I think it leads back into all those examinations of the individual jurors. And how do you unring that bell? So, you know, even if the court doesn't grant a mistrial, I just putting the state on notice, or the court on notice. I mean, I think at this time, Mr. Bryan's entitled to a severance if he wanted. I haven't had a chance to confer with him, but I mean, they put us in that situation, and it's just unfortunate. And that's that matter. I have a second matter, but I'll sit down while we finish the first.
And I just want to add what I understand to have happened, because we did have this conversation where during the presentation of evidence, the state would question Officer Lowry, Investigator Lowry, about what happened on the 23rd by the Glenn County Police, maybe the 24th, and then just end it. Not talk about the lapse of time as a factor in this matter. And what Ms. Dunikoski, in fact, did is talk about the investigation stalling and nothing happening until the GBI got involved, which is factually incorrect, because we know Glenn County Police sent audio and video off to be enhanced. We know they did other things, canvassing neighborhoods and things like that. So not only has she reneged on our understanding of an agreement, but she's now said something factually incorrect that it's incumbent upon us to correct, which is questioning officers about what they did after February 23rd, after February 24th, 2020. Because they, in fact, did continue to work on the case. Ms. Dunikoski has now misled the jury and rung a bell and asked them not to listen to it.
I assume that's,
I'm only standing so that I don't have to.
I know, but Mr. Sheffield had started, so I understand Mr. Rubin
You're not
addressed the
only-
issue. Well,
Yeah, I'm just gonna,
yeah. No, I was not suggesting we have two lawyers for the same party
We're not.
jumping up. Okay. All right, from the state.
Thank you, Judge. The state had filed motion 4.54 to exclude mention of reference to our argument regarding District Attorney George Barnhill's letter to Captain Tom Junt, Barnhill's meeting with Glenn County about his case, and Barnhill's opinion about this case. That was the motion in limine. The state did agree that we weren't going to go into Jackie Johnson. This was before her indictment. However, the state objected to the voir dire question about the time lapse, because to the state, that inserted the issue in the jurors' minds about the lapse in time. The state felt the question of, do you hold it against the state with the Jackie Johnson situation? Do you know George Barnhill? All those questions, no one from the defense objected to. But, Judge, more importantly, it was not the state's intention to put anything before these jurors. We all know that nothing happened after the 23rd and 24th. There are a few things that did take place, and Parker Marcy is going to testify to that, because he did send away video to ROCIC, and they did enhance it, and I just played it. So the things that Glenn County PD did in the time frame between February and May, that's going to come in because Parker Marcy is going to testify about that. I was simply trying to segue between hey, they took these interviews, they did all this stuff, and then the next thing happened was this. I thought the most delicate way to do that was to say the investigation stalled, nothing happened, the GBI comes in on the 5th. And once again, what I say in opening is not evidence. So right now, in my opinion, I have not violated any agreement I had with the defense in any way, shape, or form by trying to delicately segue between all of this stuff happened on February 23rd and 24th, and then the GBI comes in on the 5th with a simple segue that certainly doesn't open the door to anything they have to rebut and or address, simply because Glenn County is going to talk about what they did in the interim, and we all know that the GBI came in on the 5th. So I didn't mention Jackie Johnson, I didn't mention Barnhill, I didn't mention any of the things Mr. Goff says, so right now, the state's in total disagreement that the state violated any agreement with the defendants, and there's no need for anybody, I think, to introduce any evidence of anything, because we are going to introduce the evidence of what Glenn County did do in that interim, and then the GBI came in on the 5th, and Dial and Seacrest and Kelly will testify to what they did at that point in time. We ask that you deny Mr. Goff's motion for a mistrial or for any other curative instruction. I'm not really sure what the defense is asking for.
Curative instruction, that's why I was clarifying.
Yes, Your Honor, we don't want to re-ring the bell. I respectfully disagree that that was a delicate and smooth way to transition. The delicate and smooth way to transition would be, since this was opening, to let the jury know that she expected the evidence to show here's what GCP did, and then in May, here's what GBI did when they came in. So my request to the court is to either inquire of or to make sure that the order is secure, that the court accepted, and that was, we are not going to discuss in any way this period of time and characterize it as a stall, a lapse, or an absence of activity or action.
And I think I heard that from the state. Ms. Donkowski, I think I also heard that it sounds like there's a disagreement about how artfully the transition was made from the GP, from the Glenn County Police Department portion of the opening to where the GBI came in. Lawyers have a lot of opinions about how artful language may be, and whether it was smooth or not. I think I understand what the motion is. My understanding is that that is not going to be that this period of time that occurred between the initial incident, as I think it was defined, and the arrest was not going to be brought before the jury as a part of the case in chief.
With the exception of whatever Glenn County PD did as part of their investigation, sending things off to RCIC.
Yes. Obviously, part of the investigation. That's my understanding of where we are.
Thank you.
Okay, so that's clear. As to the mistrial, the court is not going to grant the mistrial on this matter. I believe yet another matter.
Yes, Your Honor. Because it's still fresh in our minds, I want the court to note that we're moving the court to reconsider the order granting the state's motion for a 3-hour closing argument, because what we just heard today was an 1 and 35-minute opening that had a whole lot of closing in it. So because that's the case, I don't believe there's any legitimate reason to allow the state to do this again, while the court did sustain, I believe, both of our objections to the way that Ms. Donkowski was presenting the opening statement. The only remedy that makes sense, even though she continued to do it after you sustained the first objection, is to limit the opportunity for her to basically re-close even longer at the end of this trial.
Was that motion, you said the motion will be made. I assume, you said the motion will be made to
No,
reconsider.
I didn't mean that. I am making the motion now so that you can be aware of it while everything that just happened here during opening is still fresh in your mind. Thank you.
No,
Different matter.
no, a different matter. But, you know, it's not completely different. I take that back.
I'm assuming if one of the defendants has made a motion, that the state's going to have an opportunity to respond before we get into separate matters. When you stand up before the state responds, I assume that you're joining or adding. So from the state.
Thank you, Your Honor. You did sustain both of the defense's objections to my opening. The fact that it took me an hour and 35 minutes to explain all of the evidence I anticipate is actually the reason I need 3 hours for a closing argument. And that closing argument is not going to take place this week and or next week. It will be probably 7 to 10 days from now. So the state requests that 3 hours for closing argument. The state does anticipate splitting that, and hopefully will not use all of it. But the fact that there was this much evidence, and I didn't even play all of the videos involved in this case, and it took me that long to get through it, means I really do need those 3 hours. Thank you, Judge.
Yeah, at this point, the court's ruling remains. Motion for reconsideration is denied. We'll get into the evidence. If for some reason the court needs to review that, I'll go ahead and do so. Mr. Sheffield,
Yes.
You had a separate matter?
I had
Mr. Goff.
Your Honor, I'm asking that the defense be allowed similar length and latitude in opening statement. And since I know the court is concerned about scheduling, I will be reserving, deferring my opening statement till the conclusion of the state's presentation of evidence. And I fully expect the same hour and 15 minutes to hour and 30 minutes that the state took, and the same latitude in statement as opposed to argument that the court so graciously allowed the state.
Sure how to respond to that. If an objection is made, I would suggest that we stick to what you, let me back up. So I normally don't think it's a terribly, the optics of this in front of the jury, particularly when they're sitting and listening to openings, a lot of interruptions, a lot of objections, because most lawyers that we have, particularly in a case like this, have tried a case before and understand what an opening statement is. A couple objections were made.